case number 24-214 CF. And at Mr. Carver's request, we had filed a request to reduce his bond. The motion is rather straightforward. He was arrested a few weeks ago, and the state has since filed an information charging him with 1 count of trafficking of methamphetamine, 1 count of possession of ammunition by felon, constructive possession, and 1 count of possession of paraphernalia. The bond that was set by the first appearing judge was $91,000, and Mr. Carver simply does not have the financial means to come up with a bond that high. Mr. Carver is a resident of Gulf County, has been here most of his life, if not all of his life. And I've had some consultations with him, and he's assured me that if his bond was reduced and he was able to get out of jail, that he would return to court as you direct him to return. So that's where we're at. We're just asking the court to consider a reduction of the $91,000 bond, Judge.
Yes, sir. Mr. Patterson.
Mr. Carver has an extensive criminal history, including attempted burglary of structure, possession of controlled substance, battery by strangulation, sale of methamphetamine, two charges or convictions for tampering with a witness, and then a multitude and myriad of misdemeanor offenses. Mr. Carver was just released from the Department of Corrections in March of 2024 for sale of methamphetamine. And here we are back for trafficking at a level 8 offense. I'm sorry, level 7 offense. 14 grams or more. He is subject on his score sheet to a minimum prison sentence of 76.65 months, but that does not include any minimum. That would include minimum mandatories for the trafficking charge. I think the bonds are reasonable given his criminal history and circumstances and his recent release from Department of Corrections for drug offenses.
Is it 14 to 28 grams? Was that the 3-year mandatory minimum?
It is,
Okay.
Judge.
All right, Mr. Carver, I'm going to deny your motion for bond reduction, sir. We should already have, if we don't have a return date.
Yes, we have a return date, Judge. He was here Tuesday for his,
Okay, perfect.
he was here Tuesday for his arraignment.
We'll
We've
return
already set
tomorrow.
that.
Richard Bibb. And this is a failure to appear, hold without bond. I've reviewed the motion. Looks like he had car problems, but he called you on the same day.
He did, Your Honor. That morning the morning he failed to appear in court, he did contact my office and let us know that he was having car issues and was not able to make it here. And of course, the day of court came and went, and Mr. Bibb was not able to make it down here, and Your Honor had issued the capias for his arrest. And that was served on December 4th, and he's been incarcerated since then. In addition to that, Mr. Bibb was in the process of working to get a hip replacement done. And he still needs to get that done, so if the court would consider reinstating his bond so that he can get out and take care of that health issue. But I can also tell the court that when Mr. Bibb was out, he maintained contact with me and had been here for all of his other court dates to my knowledge.
All right, Mr. Patterson.
Your Honor, given the circumstances surrounding this, and I don't have any, I'll leave it to the court's discretion what the court thinks is appropriate as far as reinstating bond or issuing a new bond, but I have no objection to Mr. Bibb being granted a release.
All righty, I'll reinstate your bond, Mr. Bibb.
Thank you so much, sir.
Do we already have a return date?
We do not judge, well, February 4th, we
All right,
do.
we'll see you February 4th, sir.
Thank you very much, Your Honor.
When you get out, just make sure you contact my office. So
Yes, sir. Thank you very much.
All right. I thought that one was a little neat. That shows you the difference between Florida and some of the other states. The guy missed court the first week of December, and it was January 9th before he got to see a judge just to say, oops, I didn't make it to court, but I contacted my lawyer. So that shows you the difference between the states. That's kind of amazing there to me, how different they are. Here we're going to go to Panama City to Judge Clark. We're going to stay in the same judicial district there. He had a good pro se the other day, so let's see where that goes.
So what was set for today?
Yes, sir.
I believe it was a motion here.
Is that the motion to return seized property?
And the request of my videos.
All right, you may proceed.
On the videos, they They were told me, as the videos from the self card on transmitter, they told me that I had to have a court official in order to receive those videos. But last time Miss Morgan McCaffrey was here, she told me that they no longer had the videos, but I've been calling every week and they still had the videos up there at the Selfco. So, and without those videos, sir, it's gonna be hard for me to defend myself because, you know, I really need those videos to prove, you know, what was going on, what happened, the way it initiated at the store. But besides all that, my phones and everything that was seized.
All right, let's take up that. But this is the motion for video and police body cam. Mr. Sullivan or Mr. White? Who's got that case?
I believe it's going to be Mr. White's, but I'm prepared to give the motion.
Okay, go ahead.
Similar to kind of what Mr. Shepard was asking for, Mr. McCoy is asking for videos that are not in possession of law enforcement. They're stored videos. I don't have them. I can't provide them.
I agree with that. What about the body cam footage?
I don't believe there is body cam, but I'm not prepared to say that for certain. So I will reach out and check. And if there is, that will obviously be provided. But looking at this was the Bay County Sheriff's Office SID unit is what he's asking for. They only recently got body cams, and I don't believe there is, but I will double check on that.
What I'm gonna reserve on the issue of the body cam and direct the state to see if the law enforcement officers or law enforcement agency has body cam. As far as the footage, I know you're asking for the footage from CEFCO, is that correct?
Yes, they said I had to be a public official to receive the body cam footage, the store footage.
I can't direct the CEFCO to, I mean, you'd have to have CEFCO here in a motion. I mean, I can't direct, it's just like the two arguments I've had before. State didn't have the right to go and direct that without some sort of.
Well, Ms. Morgan already said she went up there and they didn't have them, which was not the truth. And
There's nothing I can do if she said that. I mean, you can direct, you can go.
I mean, I have voicemails and recordings from the managers at the Selfco. My thing is, I just want it on the record. I want to know why she lying about the videos.
I don't care about that. I'm gonna strike that from the record because it means nothing to me on your motion.
Strike that from the record, Mr.
I just struck it from the record. If you want that information from CEFCO, you're gonna have CEFCO here. I don't know what you're asking me to do. You're asking me to have the state go get it from them. And I've just had two motions like that. I don't think I have the authority. No one's given me any authority or any authority that I can direct the state to do that. I'm gonna reserve on the body cam because I think if there is body cam, you're certainly entitled to that. And you may be entitled to that from CEFCO, but you'll have to get that from CEFCO. Unless the state has it if the state had it in their possession, you're certainly entitled to that.
Well,
They're indicating they don't have it in their possession.
The state says she already attempted that, so I figured why would it be an issue to go, you know?
But she said she didn't have it, right?
She said they didn't have it, which they do have it, because I call every
But
week
I'm gonna
about
deny
the
that
video.
motion. All right, you have a motion for seized property, is that correct? And what is that?
Cell phones,
All right, your cell phone.
yeah.
Any reason that Mr. McCoy can't have a cell phone back? All right, Mr. McCoy, I am going to grant that motion. You may want to,
Actually, two cell phones, but okay, I appreciate it, Mr.
what I'll do, you need to draft an order and present it to my office, or can they do it from the minutes, Madam Clerk?
I mean, I put agreement to defendant's cell phone.
All right, to the cell phones, whatever cell phones are in their possession that Mr. McCoy's, I'll grant that motion. If they don't do it by the minutes, you'll have to do an order, but I'll direct them for the minutes, okay?
All right, sir, you said I would have to put in the order to order Selfco.
No, I'm gonna see if they'll do it from the minutes of court without you having to present an order.
Yeah.
But if you have to present an order, you'll have to prepare an order.
I was speaking on the video, sir, just so I got to understand.
Well, I'm denying the motion on video, and if you want to do an order on that, you have to present an order. There's no authority for me, and there's no authority for me to direct not the body cam, the videos from the store. I'm directing the state to check with law enforcement to see if they have body cams, and I'll grant that motion if they have body cams. They tell me they do.
So you said even if I was to subpoena the store people here, you would still deny me that? Because that's how I'm going to prepare adequate defense for myself, sir. I'm just saying, are you still going to deny
It
it?
doesn't matter. You're asking me to do stuff that I don't have the authority to do.
I subpoenaed the store here, like to come here with the.
I don't know that-
I can't
I
go receive those videos.
You'd have to
be a public
you'd have to provide case law to me that they had to give it to you.
That's the only way I'm prepare adequate defense. That's evidence. I
It
mean,
doesn't matter to me. Just because you need it doesn't mean they have to give it to you.
why would they withhold evidence though? That's the scope to it. That's impeachment evidence.
Listen, that is what the state has in their possession. If the state didn't have it in their possession, you're asking a private citizen, you may be able to get it. I don't know, but you're going to have to provide me legal authority to that. Fair enough?
If I show you
That'd be just
by
like,
law,
that'd be
by
just like
rules,
you having a Ring doorbell and there's something happens in front of your street and it's in your possession. And whoever's the defendant in that case wants you to give it to them. You don't want to give it to them.
it's a
what-
business, sir. This is not somebody's house. This is a establishment.
Yep.
This is where
The
they.
same thing. I'm denying the motion now without prejudice. If you can find case law, we'll set it for the 21st and see where the body cam's at.
I'll be
Okay.
sending it in there, sir, with the case law show you sir, that I need that
Yeah.
evidence has to be provided to. I can show you that.
You have to show me the authority, sir. Yes,
I
sir.
will, sir.
Very good. All right. Oh, sign a notice, 21st. And remember, at any point in time, you can ask for an attorney.
Don't need one.
So far yet, that's for sure. I'll grant you that.
Well, sir,
I'll grant you that. All right, is Mr. Arnold out?
You know, I was whenever I was watching this, I was thinking about how simple my job is compared to a judge's job, and how many times a day do I think people are idiots for thinking they can do my job? I just wonder how, just the patience that judges and lawyers must have, for people, because one, I think their jobs are overrated, but two, there's no way in the world I could do their job or even think the way they think. So it's neat to see how judges do what they do. Um, this judge here, somebody was saying that he always looks mad. He does. He always looks like he's just madder than hell, but he's not. He's a super nice guy, and just like there, he just cuts up in that. But he takes his job real serious. Probably a lot more than Judge Van. Judge Van likes to make light of it, but in the end, they all go to lunch at the same place. They all sit down with the same groups, and they're all the same folks. So here we got one more, and then we're going to go into another judge.
Mr. Leach, are you still in the Zoom room?
Yes, sir.
All right, Mr. Arnold is coming to the front of the bench.
And Judge, we're here for trial management. We're scheduled for trial February 3rd. Your Honor
Okay.
did issue an order denying our motion to suppress. So we are ready for trial. The only issue is I have a calendar conflict. I'm scheduled for another trial the same week in Tallahassee. That is a homicide case that is actually older than Mr. Arnold's case and involves multiple defendants. So I filed a motion to continue this trial because I think the rules of judicial administration would put priority upon the other trial.
Mr. Sullivan?
I've got no objection, Your Honor. I would ask for that March 3rd trial date.
All right, March 3rd, I'll grant the motion. March 3rd at 8:30. We'll set it for February 21st at 9 o'clock for trial management.
Very good, Your Honor. And I have nothing else scheduled that week, so this would be the priority.
Very good. All right, have a good day.
Thank you, Judge. You too.
Mr. Salim?
Good morning, Honor.
Morning.
Judge, before you is Harry Evans. He's here in case number 21-2800. And Judge, a while back, you had sentenced Mr. Evans in pursuant to a plea agreement with the state to 10 years of probation, 5 years on each count, and a withhold of adjudication. Since that time, Mr. Evans has successfully completed everything that was asked of him. Although he's been on probation for a little over a year and a half, it has been around 4 years since the underlying incident took place. And in light of that, Mr. Evans is requesting relief in the terms of an early termination, if not an immediate termination, then perhaps something less than the 10 years. The date of the alleged offense was July 8th of 2021. So we're not quite at the 4-year mark. We're probably about 3.5 years as a ballpark figure from the date of the alleged offense without any interactions with law enforcement. I'm happy to place Mr. Evans under oath if the court wished to hear from him regarding why he wishes to have this relief or how it's affecting his ability to travel for his daughter's competitions and that sort of thing. But that's basically why we're here today, Your Honor. And Ms.
State's response.
Your Honor, this was originally an aggravated battery with a firearm. Mr. Evans faced a 10-year minimum mandatory in prison. It was pled down, given to several circumstances and mitigating factors that Mr. Evans presented. However, as part of that plea agreement, it was to ensure that Mr. Evans continues down a path of nonviolence, so to speak. Mr. Evans has gone, I think Mr. Stallings said 4 or so years since the time of the offense. He's only gone a little over a year since accepting the plea offer of 10 years probation. So the state's not opposed to early termination in the future, but at this point in time, the state's objecting, and there just needs to be more time to make sure Mr. Evans continues down a lawful path.
Okay. All right. If you want to swear Mr. Evans in, please.
Always swear the testimony about to give the truth, the whole truth, and nothing but the truth, so help you God.
Tell me,
All right, Mr. Evans, obviously, we're here today because you're asking the court for some type of early termination of probation. Go ahead and explain to the court how this is interfering with your day-to-day life ability to work or take care of your family or attend your daughter's various competitions that she has. Basically, why are you asking for this relief?
Yes, sir. I have to submit a travel pass every time I want to leave the county, and it's kind of hard to do that. And I don't like missing my daughter's events. I know I messed up. I haven't messed up since. It's the only offense I've ever had, and just asking the court some leniency.
And with respect to the travel, is this cheerleading
Yes, sir.
competition?
Yes, sir.
And how old is your daughter?
She's 14. She's been doing it since she's 3.
All right. And I presume you have had no issues with your probation. It's your testimony. You've completed everything successfully.
Yes, sir. I've completed everything successfully, paid all my fines, and I'm in a IATS program of calling in once a month.
In your honor, in the event the court's not inclined to do an immediate termination, we would just ask that, there not be prejudice if you did want to file again in the future, or perhaps have the sentence reduced from 10 to something less.
Probably filed. What I'll do is I commend you for how well you've done. I'm not prepared to grant the motion at this time. I will deny it without prejudice. You can file it in the future,
Yes, your honor.
and would encourage you to do so, as long as you're still doing exactly what you're supposed to do.
Yes, your honor. We appreciate that, Judge. Well, thank you for allowing us to refile.
Yes, sir.
Yes, sir.
Mr. Hatcher, you ready?
So Gina, I think it was a domestic violence. If I'm almost certain it was a domestic violence charge. Instead of going to prison, he ended up getting 10 years probation. And so 1 year after he was into his 10 years probation, he was trying to get off probation, saying that he had to go to his daughter's cheerleading events. Just seems to me like you don't do stupid crimes like that, and you won't have to fill out paperwork. And I'd much rather fill out paperwork than have to sit in jail. So give it a couple more years. I know my son also got 10 years probation, and they told him in 5 years he can try to get off probation. So Florida likes to give the probation, or whenever they give it good and make it nice and long. Me and my son were just going over the money. It's costing around $1,000 a month just to keep him on probation and pay the fines and stuff. So it's certainly expensive. So I'm gonna play a video from People in Court. She's got a really good channel. Go check out her channel. Show her some love. This is a video from hers that was really interesting, and there was no way in the world I would have caught this court, and so I wanted to show it off there.
Let me go ahead and call cause number GN 24009532, Lee versus Texas Workforce Commission. Just make your introduction.
Gina Bost with the Attorney General's Office on behalf of the Texas Workforce Commission.
All right. And Ms. Lee, are you representing yourself this morning?
Yes, I'm going pro se.
Okay. All right. And it is the state's motion. So Ms. Bost will go first.
Thank you, Judge.
Okay.
And I'll keep to my time. And throughout the hearing, I'll say TWC for Texas Workforce. But the underlying issue today stems from plaintiff's unemployment benefits. She was employed by Goodwill Industries from November 2020 until November 2021, at which time she was terminated. Administrative hearings were held, and ultimately TWC found in favor of Ms. Lee and awarded her benefits. And payment of those benefits can be found in Exhibit A, and that's pages 13 through 18. It shows the payments and the dates. But in the time since then, Ms. Lee filed a petition alleging a slew of intentional torts against the TWC. In December of 2024, TWC filed an answer along with a PTJ, a plea to the jurisdiction. And our three main points for why her lawsuit should be dismissed are sovereign immunity of TWC, mootness of the underlying unemployment claim, and also statutory defect of her original petition. And I'll take each of those in turn. So sovereign immunity, it prevents people of the public from being able to sue a governmental entity for intentional torts. And that's laid out in the Texas Tort Claims Act. She's alleged such intentional torts as defamation of character, criminal fraud, and TWC has never waived sovereign immunity for these types of allegations. And not only that, they're unactionable, but they're just baseless. They're not, there's no evidence behind them. And the second point is mootness of her underlying unemployment claim. As I stated, she's already been paid her benefits. She was awarded, TWC found in her favor, listened to both sides, listened to the employer's side, to her side, and found in her favor. So there's no judicial review for you to even consider, Judge, because there's no decision in opposition to Ms. Lee. So, I mean, it's just moot at this point. And the third and final reason to dismiss her claim is statutory defect of her original petition. She did not name a required defendant, that being her employer. The Texas Labor Code lays this out. Any party who would have a legal or financial claim or could be potentially harmed, if they were involved at the administrative level, they need to be involved at this level too. So her failure to name them is a statutory defect. And Exhibit C is the Texas Labor Code, and Exhibit B is the Texas Tort Claims Act, which show what I've already referenced. For these reasons, Judge, for these three foregoing reasons, we ask that her claim be dismissed, her lawsuit be dismissed in its entirety, sovereign immunity being really the big one, and also mootness of her underlying unemployment claim, and statutory defect of her original petition, failing to name a required defendant. Thank you, Judge.
All right, thank you. All right, Ms. Lee. You can unmute yourself and let me know your response to the motion or to the plea.
Okay. Well, my motion, that is that it was absolute what she said. We absolutely did come to an conclusion on that, and the whole entire incident was reversed in my favor. But what I am having an issue with was the whole entire time that I was going through the appeal process, I was being sabotaged. We went through 3 separate appeals. It got to the point where we had to go through 3 separate. The first one I missed because I was not notified. I had received an email. I don't know if you can see this because I want to submit evidence as well. But there was an email sent from executive staff saying that they had to escalate the situation. At the time, I sent my appeal in December 15th, 2021. As you can see, December 22nd, if I can put it up there, where's the camera? December 12th, 2022, I received this email saying that it was going to be escalated, which is 3 days shy of a year from when I first originally put it in. At that time, it's just escalated. So she was basically letting me know no one has touched it. Okay. Right after that incident occurred, on the 19th following, right after, they had the appeal. I was never notified about it. On the 12th, it stated in there that she was escalating it. This is the, if I can get it over there. You see that date, the 19th, they had it. Okay, on the 12th, she was telling me it was escalated. I was told that I was mailed out a packet on the 6th. And I'm not understanding that if I was mailed out a packet on the 6th, why was it not in the system on the 12th? As you see, this email was from executive staff. So how is it that on the 12th that she didn't see anything saying that anything was mailed out to me on the 6th? She didn't say anything in there about a predated time of the 19th. So they just basically had the appeal on the 19th just to clear it out of their system because it's been sitting idle for a year. So that was just their way of doing it without notifying me, because as you can see on here, neither one of us was notified. I don't know if you can see that. We're neither one up here, neither me or the employer. We were never notified. They basically just botched an appeal and just put it together. As a matter of fact, this is the mailing list showing that there are no addresses on here listed to even be mailed out to. So we were never notified. We went through the second appeal. The second appeal was basically sabotage as well. I was emailing the only person that I had for correspondence up until the 26th. They had the actual appeal on the 27th. On the 26th, before the 27th, I sent him and I told him that these are emails that I keep getting. If I can get that in front of there. These are emails that I keep getting, but I'm not getting the information that I'm supposed to be receiving. So basically, here it is, the 26th, and I'm basically emailing him, asking him again for information. I also called him again on the phone on the 26th, called him at 11 o'clock. I told him that I was going to call him. As a matter of fact, I have that paperwork, that email showing that I told him I was going to call him on the 26th. I had it set up to call him on the 26th. He did not answer the phone. He did not return my phone call. So when the 27th came, he gives me an email telling me that I'm going to be listed as a no call, no show. And I was like basically I was not there. So a non-appearance. So here it is. The actual appeal happened at 7:30 that morning. Here I am emailing him.
Ms. Lee, are you still there?
Okay. Yes, I'm still there. I'm sorry. It's just the phone rang. I'm sorry. I should turn off my ringer. But as you can see on here, on the 27th at 3:02, I
think this lady's got everything written out on paper and didn't give none of it into court. I don't know how in the hell you've got worse internet than me and you think that the judge can see it through your phone. I don't know. So y'all put in chat who thinks she's gonna win. Yes, Critter. Within my eyelashes, who do you think is gonna win this one?
an email saying I haven't received anything. Okay. I don't know if you're seeing that I haven't received anything. Okay. So then he responds back to me at 3:33, which the appeal happened at 7:30 that morning. He responds back to me at 3:33 telling me that he's going to give me a non-appearance and that I was going to get that day. Well, for one, I've been emailing him ever since the 23rd, asking him for the information for that appeal. And he never ever sent me the information. He could have literally given me the time and the date, which is what I was asking for. So from the 23rd all the way up to the 26th, I'm contacting him. I'm calling him. I'm letting him know that I'm calling him. As a matter of fact, let me find the one that basically says, I'm calling you on the 26th. Okay, here it is.
Ms. Lee, I need to understand, what is your response to
I'm calling him on the 26th and he never
I
responded.
need to understand what your response is to the plea to the jurisdiction. You
The plea
haven't
to
told
the
me anything about that.
Okay, the plea to the jurisdiction, if from my understanding, what a jurisdiction is that you're trying to not have it in a court because you're out of state. That's my understanding of a jurisdiction. But either way, if you are out of state or whatever the case may be, there are grounds for reasons for having this court case. I was clearly sabotaged. And I do want that addressed. This was going through a hearing process that was supposed to establish whether or not I was supposed to receive my benefits. It was sabotaged. It lasted over a period of 2 years, which is entirely too long. That is way over the allotted amount of time. It was very lengthy. What I was told, that it only takes 6 weeks in order to get something like that done. So it stretched out over a period of 2.5 years, ma'am. Sabotage after sabotage. After the first appeal on the 19th, even though they had my email to contact me on the 12th, I was never notified about the 19th. I was told in that email to wait until Friday. They will contact me. If they contacted me, then that will be okay. If not, I guess it's fair game up to me to call. I called and called constantly, gave emails constantly. No one returns anything to me. It got to the point where 6 months later, I physically had to walk into the building myself to get the information. And when I walked into the building, they couldn't even give me any information. So basically, after all that time that it sat idle for that whole year, somehow it got lost. So I was asking them, when it got lost, how is it that you all had the appeal if it was lost? So here it is, the 24th of May, 6 months later. I'm going in personally to get this information, requesting information about it. They did not give me information about it. We went through another runaround. So I had to end up getting in contact with Greg Abbott, the governor. He basically got in contact with TWC for the 6 months that I was being avoided. No one called me back. No one wanted to call me back. They basically just ignored me. 3 days after I received the email, I sent the email to Greg Abbott. I got an email response from the head commissioner, Ed Cerna, and he gave me his cell phone number. So this is a person who was avoiding my emails for a whole 6 months and didn't want to talk to me at all. But as soon as I got in contact with Greg Abbott, he decided to return my call. So they're playing these little cat and mouse games, blowing me off, basically. Like I said, my information got removed some kind of way. It came up misplaced. I had to resubmit it, and then we had to go through it again. Now, the third appeal was only given to me because I spoke to Governor Abbott. I have that picture in my phone. I honestly want to have that sent to you. That's why I wanted to do it in court. But I'm actually outside the court doors right now as we speak. But they basically just kept prolonging it. On the third appeal, they did not contact Goodwill themselves. I had to personally contact Goodwill to make sure that they were appearing on that hearing. They appeared at that hearing, and that's when it got resolved. But the thing is that I have been telling them that they had the wrong information from the beginning, even before I got the denial. I was telling them, you all had the wrong information in there because I was relayed over the phone when I first applied that it was already in the system on some company policy violation that never committed. That was the reason why in the third appeal, the decision was reversed, because Goodwill let them know that there was no company policy violation within their company that they reported. So TWC had the wrong information, which was basically given to them by the management of Goodwill that basically sabotaged me into the wrongful termination. That's the whole reason why I was terminated. And it's a lot going behind that. I have a case on them right now dealing with that. So it's just a lot of things about that happened. They never called the headquarters of Goodwill to get this information to deny me. And the whole entire time when I'm telling them, you never called the headquarters, you called the managers that set me up for sabotage. They, of course, told you the wrong information. You said you did an investigation, but you did not call the head HR, so you did not do an investigation. That's what was stated on the decision, which was the decision was, I was denied for company policy violation and misconduct. I don't know if you can see that, but I have all the evidence. I actually have, like, literally, I mean, if you really honestly want to see how much evidence I have, it's literally pathetic. It's
Ma'am,
literally
you're way
pathetic.
over your time. This is a 15-minute hearing, and you've now
I
used
get that.
about 12
You're
minutes.
trying to stop me because you don't want the truth to come out. Your company was sabotaging me. The only reason that I can think of for you all to sabotage me is that you saw African American on my profile. I have never met you. I've never met Robert. I come across Caucasian over the phone. I've been mistaken so many times because I speak proper. So there's no way that he knew that I was Black other than my profile. So other than that, if we never met, what was the reason for animosity to have sabotage being done? What was the point of even holding me off all that time? It took
Isn't it a little racist for her to say that she comes off Caucasian over the phone because she speaks properly? I thought that was against the rules to say stuff like that. I wonder if she's gonna get in trouble for it.
years. Within the 2 years, I have been displaced. I am homeless now. The only reason why I look this way is because I borrowed an outfit from my first lady at my church because she wanted me to appear and have a good appearance. I have been homeless for the past 2 years, sleeping outside on the ground while you all have been playing with me. And I have told you all this from the beginning because I was evicted from my house February 25th, 2022. You all have known this. So instead of handling me diligently, knowing that I was evicted because you all wrongfully denied me, and I've told you this from the beginning, which we had to go through 3 appeals for you all to understand that, and it came back in my favor. You all have been playing with me all this time. I want to be compensated. I've lost my house, my car, all my possessions over your manipulation. And all you had to do is process it. If you would have processed it and did it correctly from the beginning, it would have never been a denial. That's why it got reversed. So I basically went through all of this for nothing. There's no way I'm being in this situation that I'm still in and just eating it. It's not happening. I have a right to be compensated. This was manipulation to the fullest. I wish I could show you all the other information that I have as well, but I do have the emails that I sent to Governor Abbott explaining the whole situation as well, and it's evident. And like I said, if this does not get handled properly within this court, I can absolutely take it to the Supreme Court just because Governor Abbott is involved. I don't think he wants it to go there. That's why he tried to give me the third appeal. I just want to be compensated for losing my house, all my possessions, and the transition of displacement all this time, pain and suffering for no reason at all.
Okay, thank you.
I'm finished.
All right, thank you. All right, Ms. Boss, it's your motion. You have the final word.
Judge, I mean, I could reiterate, sovereign immunity, that's, anything she's alleged is unactionable. TWC decisions, yes, they listen to both sides, they look at the evidence, and ultimately they found in her favor. They have to take the time to make a decision that's not arbitrary or capricious, and it was in her favor. So her damages are not in any form the cause of TWC, and that's it, Judge.
Okay, all right. I'm going to take a look at the motion. And
may I address?
No, you're out of time. This was a total hearing of 15 minutes, and you used 15 minutes.
I understand, ma'am, but this is evidence. This is not allegation. This is evidence. It's not allegation.
Okay.
So I think it should be waived.
The hearing is over, ma'am. I'm taking the motion under advisement. You'll be notified of the decision. Thank you.
I appreciate it. 'Cause I need to know. This is just over the top. Thank you.
All right. Y'all are excused. You may have a great weekend. Thank you so much.
Thank you, Judge.
Thank you.
All right. So what y'all think of that? I like Marty's comment there. How come the sovereign like their services but not the responsibility? They love to take all the credit but don't want to pay any of the bills for it. I don't know what she did, but I believe she'll tell you what she did plenty of times. Looks like we got celebrities in here. We got Kathy with Court Vibes, Sevo Girls stopping by to check it out, and so everyone's. We even have, yeah, Linus is here. Whoever Linus is, I don't know who Linus is. Um, let's go to a quick Judge Fleischer one, and then we're going to go to Judge Simpson. We got a good one with Judge Simpson. So let's do Judge Fleischer first.
Named Elio Terrence. And he's here today, Your Honor. This was rolled over from yesterday. And we have an issue on the PTI. We need to bring to the attention of the court. There was a violation. Yes, sir, he is here.
Come up, Mr. Leo.
There's some issues, violations. Mr. Nathan is PTI chief is willing to agree to extension of the PTI. He had just almost about to finish it when the violation occurred. But they're willing to agree to a 6-month extension. We're before the court today to request to see if the judge will agree and approve that 6-month extension on this PTI. I'll let your staff here advise you on those violations.
A lot of it depends on how he was doing. Has he done anything? Has he done most of it? What are the hiccups? Is he continuing to use?
Yes, sir. In that regard, he is scheduled for 2 classes. One is being November 13th. What are the 2 dates?
November 13th, 15th, 6 p.m. to 9, and second class is on December 2nd, from 6 to 9. That's virtual.
So those are the 2 classes they had set him up for.
What has he done?
He has to complete the GWI education course and the effective decision making. Those are the classes he's registered for.
Wow, he hadn't even done that, and it's.
So he's claiming financial hardship, so they're doing all of the programs in-house. His device has been in lockout since July. They've been drug testing him more frequently because of that. His last 5 drug tests are positive for marijuana.
You don't say. If I test you now, what are you going to test positive for? Really? Really? I'll send you right now. We'll see.
His last drug test was October 16th, and he was positive for marijuana. So they want to extend him for 6 months to allow him to complete the 2 classes in Iowa.
Joe, he hasn't done anything. All he's done is continue to smoke weed the whole time.
Your Honor, I did sit down before he approached, and he assured me that he had stopped. I told him, talking to you, and that you would test him, and, I gave them the option because, I was willing to speak with the DA too to see where they wanted to go with this and talk with the client as well about that. One of the things about the machine, he says, as you said, he's been out of a job, and the probation officer's working on him knows that, and that's why he hadn't been able to pay for the installation of the machine, which is no excuse.
But he has enough money to smoke weed. People spend money where they want to spend money, right? If you truly want to do something, there's always a way. So when someone is not working, it's because they choose not to work, not because they can't work. If you really wanted to work, you could. It's a matter of you just don't want to. And I get it. But don't come here asking for us to be lenient when you don't do anything. You've been in lockout since last July? You've been in lockout for an entire year. And Joe, if I send you for a test right now, what are you going to test positive for? Man.
I ain't been smoking at all October.
Look,
I just have no marijuana and nothing. I don't do no other drugs.
No, you're in a diversion program where the idea is you're supposed to stay clean. And when you do, the reward is that they dismiss your case. And if you do, you don't even have to do that much. All you got to do is 2 classes, right? And just stay out of trouble. And they dismissed the case. Joe.
Yes, Your Honor. Your Honor, I wanted the opportunity that if
He's been in lockout for an entire year.
I was going
And-
to talk with the DA and see if there's another resolution of the situation and see what options he wanted me to check on that. If the court was not in, I explained to him 6 more months means he needs to be in compliance 6 months.
Yeah, I'm not, and he's not been in compliance at all for anything. I'm not inclined to do another 6-month reset for him to just do nothing
Yes, Your Honor.
for another 6 months. I mean, we're delaying the inevitable. You know what I mean?
Yes, Your Honor. I
So
understand.
you might as just
Yes, sir. Your Honor, we'll talk to him right now, and thank you for the opportunity to come forward.
Sure. Joe, I love you, man. And I'd say that of all the people that come here with violations, 99% we do. But you got to show that you want it, that you really have a willingness to do it.
Yes, sir.
And when you don't, really, I mean, the program is designed to reward people who faithfully work for it. And I get that there are hiccups in life, but when you do nothing, been in lockout for an entire year, you literally have done nothing for an entire year, and all you've done is continue to smoke weed the whole time. That shows us you don't care. So why would we care? You know? All right, you guys talk. Let me know what you want to do. You must either accept or we're going to set your case for trial today. Okay? All right.
All right, so for the folks in the chat that don't know what they're talking about shut-ins and such, a couple nights ago there was a little roundtable meeting in Harris County, and Judge Fleischer was the topic of concern, and they brought up a lot of dumb comments. They were making it seem like Judge Fleischer was not the great judge, that his clothing was a distraction, and that it was not being proper to people. It was silliness. It was political. It was garbage. It was just folks that they didn't like Judge Fleischer, or they had an agenda against him, and they all got to sit around and talk. And I think there was about 30 of us total in the room, and you would think a group like that would have several hundred people watching, but there was 30 of us, and I believe 29 of us was all in support of Judge Fleischer. And so for everyone that did watch, thank you for putting up with that. For those that didn't watch, you didn't really know. And Sivo girl, I know what you're saying about Massachusetts. There's a lot of good places in Massachusetts. I went to some of the ports in Massachusetts and some of the industrial parks, and I'm just saying it was a rough area where I was at. I know that doesn't represent all of Massachusetts, but it certainly shocked me. I was, I'm a country boy, and I was a fish out of water up there, and so it was certainly different for me. So, but I'm sure there's great people in Massachusetts. I've seen great people all over the country. Some of the prettiest country towns I've seen was in New York. So I know just picking out the cities does not represent the whole thing. All right, let's go to Judge Simpson. Well, yeah, let's just do Judge Simpson.
It took longer than I was expecting.
He did tell me that
Yes.
his family has a similar property that they
Yes.
sold last month
Yes.
that would have netted enough to pay the restitution. So he's optimistic
Yes.
that this will be sold in 4 weeks and he'll have enough to pay a lump sum and pay the restitution off in full so that the victim in this case is made whole.
Give him one last shot at it.
Thank you, Judge.
February 20th, 2025. And bond continues. You know, Ms. Lundy's position isn't going to change.
I know, Judge.
So you're trying to wear her down. It's not going to happen. I'm just saying.
So, money changes things. Paying off a big lump sum like this.
Not going to happen. Telling you right now. It's been before me for years. Not going to happen.
Well, you know it better than me, Judge.
You give it your best shot.
I will. Thank you.
Esteban.
Esteban, he did turn himself in on January 13th on the warrant. He was not picked up on this case. Looking to resolve this matter and a matter that's set up in circuit court regarding child support.
Say that part again.
That he turned himself in to take care of this warrant that had been issued and another warrant that was issued regarding child support, which he's trying to resolve up in circuit court. He's looking to resolve both these matters.
But is he being held on the child support?
He's not being held on the child support. He also resolved a failure to pay out of the 14B district court that has a court date coming up next month. That also is a
what date?
I will understand 2/15.
And is he being held on that?
Not being held on that case either. If he were to be let out, he would abide by any community corrections order. Actually, we'd be requesting it based on the charge.
At the time of the arraignment, did you have a hold for the child support?
No, sir.
Motion for bond reduction is granted. Granted defendant $25,000 personal recognizance bond. Defendant is to report to community corrections for 2 times per week testing.
Thank you.
Thank you, Your Honor.
Regarding the adjournment, I don't know how long it would take to obtain the video. 2 or 3 weeks I'd be asking for.
Didn't I already give it a day?
February 6th.
Oh, yeah. I
didn't write it down.
It's
yet.
written right here.
Thank you.
Your client knew, didn't you?
He's smart, Your Honor.
No, you knew, didn't you?
Yes, sir.
He wasn't listening. We'll work on him on that.
Yes, sir.
All right.
Too worried about the bond argument.
Thank you.
Thank you.
Thank you, sir.
Well, that was one good deed I've done today. It's over now. No more. Tell him, well, it's not that big a deal. I'll reduce the bond if you give me something to work with.
That is for law students to watch, that argument.
Mr. Dukas gave a good argument. Nothing like yours.
That's true.
All right. Court just got a contender plea in another case. That's set for prelim.
Yes, yeah. So case 24F55262, just because of the timing with the mental health treatment court evaluation, that one was set for preliminary examination before the evaluation was complete. And that is currently set for exam.
So over there is Ann. Right?
Yes.
You know Ann?
Yes.
Okay. So if you had this, that may work out where we could like get rid of 2 cases and he could plead. I may or may not do it, but usually just go over and ask Ann. Because you asked me on the record, I'll probably say no, because I don't do the filing, so I don't know where it is.
Understood. Yes. So I will.
So would you like to do that today?
I would like to.
So here's what I'll do. I'll pass it. Go talk to Ann.
Thank you very much, Your Honor.
You're welcome. Ann, don't talk to me. Court calls again.
All right, hold on. There we go.
As to bound.
Well, I don't know what Consenta's bond argument is going to be. I'm not happy about that, but Mr. Mikowski Smith comes before Your Honor. He's a very young man with no history of assaultive offenses. He lives at home locally. He works a 40-hour-a-week job at Slim's Chicken. I know after I'm done speaking, Ms. Senda is going to get up and read the police report, and it might
You
not.
don't know that.
Go
with your.
Okay. Nevertheless, Mr. Mikowski Smith, if the court is gracious enough to consider releasing him, he will go home. He will stay home, with the exception of going to court, going to work, and that's it, Your Honor.
Your Honor, at this time, we will be asking that the defendant's phone privileges be revoked. He's been contacting his mom and telling her to contact the victim, saying things like, I got put at 10 in the morning, they already told me, and if I get convicted, it's a felony stuff, so I definitely need to talk to them on that. He also says, like right now today, you gotta let her know, like if she, oh my God, when we get off the phone, I need you to call over there immediately. And then he says, you make sure what's her name knows not to come at all. Basically, nobody from me, I'm good. So try to let that be known. Just try to let that be known. So that it's, yeah. Contact the victim from third parties.
And I doubt any of that was in the police report, so she didn't read it. Response.
I have no response here.
Motion for bond reduction is denied. Phone privileges are revoked. You can ask for a hearing if you'd like. Thank you.
Your Honor, I would like to, and I see that he's being held right now, but I would like to address bond in this matter. So my client was found not competent.
Hold on. Is he being held on the other matter? Okay, silence. That means I asked a good question.
You asked a really good question, Your Honor.
Yes, he is held on the other matter until February 20th on a $1,000 bond. The bond in this case is $100. felonious assault. It is, PCC.
Your Honor, I'm still gonna address bond, and if the court would allow me to, please.
Yeah, go for it.
And I understand the court's position here, but my client was.
What do you mean you understand my position? I'm saying he's held on another case, so I don't know what you want me to do.
Your Honor, I want to get this, will the court please just indulge me for a moment? I want to address bond.
Apparently, I don't have a choice. Go ahead.
The reason why he was being held in the first place was on the case out of the 15th, where he had been found not competent. And they did a involuntary commitment order, but they found him not competent and the case was dismissed. And since then, my client has just been held and held and held and held. And while he's been held because he's not competent, because he has mental health issues, he's collecting these cases. Your Honor, I don't understand how he was still held after the case from the 15th District Court was dismissed.
I don't know. But he's held on another matter at this point. Right? What is that other matter?
Hold on, yes, assault case. Which case file are you talking about? Because the FA case that he's in custody is a 15th case that hasn't been dismissed. Do you have a case file for the dismissed 15th case number?
Your Honor, I actually put it on my notice to request the adjournment.
Is it
24-1311 SM? That would not be a felony case.
That's the case he's been on. That's the only one.
That's not the case he's being held on.
Okay.
Held on is 24 F5 5228.
Thank you, Your Honor. And I'll look into that as well. But again,
and that's an assault that he committed in the jail before his 15th case was dismissed. So he was in custody on the 15th case that you're now saying has been dismissed.
Has been dismissed, yes.
He assaulted somebody in the jail before that 15th case was dismissed, and he is in custody for that September assault.
Which may explain why he wasn't released.
Thank you, Your Honor.
Motion for bond reduction denied. Go ahead.
Thank you, Judge. My understanding is that the last court date, the court told Mr. Washington that he was to come up with a plan as to what would happen should he be released. I believe Ms. Ikariakan-Ruli had to file at that time, and she indicated that he was to go into the CCOP program. She reached out to Ms. Maya Dozier, and our understanding is he cannot be evaluated for that program while in custody. He has prepared a plan, is my understanding, as a letter for the court, if the court wants to review it, is what I am told. And so his request is that the court would release him on a tether if necessary, so that he can go into the CCOP program, be evaluated by Ms. Dozier. And he does have family support here who would help him in any way, with his mother and his father are both in the courtroom. And so that's what his request at this time.
Oh, they're back. Okay. Okay. I just wanted to.
Yes, Judge. And so that's my understanding as of what occurred at the last court date, and what his request is.
So you can get into CCOP program?
Yes, Judge. Since his bond's been revoked, he's been in here 3 weeks, and I think he has faced some harsh realities that what happened.
Well, harsh realities of what?
What happens when you don't listen to Judge Simpson, when you don't follow your bond conditions.
Oh, that harsh reality?
Yes.
How's it been going?
Not so good.
So how do you think you ended up here?
By not being truthful to myself, honestly, like I said the last time, and not being truthful to you, most of all.
And there's another person you weren't truthful with.
My mother.
Yeah. Out of all of that, that was the one that upset me. How old are you?
24. I'll be 25 on a Monday.
Oh, so we could keep you for your birthday?
In theory, you could, yes, sir.
That's pretty cool. Do they do cake down there? No, they don't? No cake? Oh, Bummer. You know something, young man, and it's kind of funny because when I sit up here, I kind of look out and I see people, and sometimes I see moms, and moms are here. You may not have done the right thing, but mama's going to be here to protect her baby, or as best she can. And when she got up and walked all the way across the courtroom to get away from that other, whatever her name was, she knew you were in trouble. Mom, you want him? You do? You're so lucky she didn't say no. Because if she had said no, you'd just be my guest. Is there anything from the people regarding this?
It's a copy of the letters going to go to the court. I'd like to see it before it goes.
I haven't seen.
I didn't know if it was going to go or not. That was.
Do you need to see it?
I don't need to see it.
As long as the court continues the testing, the people have no objection to this change in bond. If there are any positive tests, we will be asking them to defend it on your vote.
Again.
If there are additional positive tests, I should say, there's 2 previous positive tests with great concern.
You know something, young man, you need to stay away from that stuff because either you're going to end up in jail or you're going to end up dead. That's just going to be the reality.
Sure.
So he's to enroll in the CCOP program. I'm going to put him on a GPS location tracking tether, and we'll reinstate his previous testing. You're on thin ice. You need to follow all of this to a letter.
Sure.
So he's to enroll in the CCOP program. I'm going to put him on a GPS location tracking tether, and we'll reinstate his previous testing. You're on thin ice. You need to follow all of this to a letter.
Sure.
His previous bond will be reinstated with a GPS tether. We'll see him on the 6th.
Thank you very much, Judge.
Thank you.
We'll talk.
Young man, don't thank me. Thank your mother for you having your freedom today, as well as your life when your birthday comes around. Mom, thanks for coming down.
Are you ready?
That's funny. Dad was there. Dad didn't do nothing. He just, I'm just saying, you didn't do nothing. Mama was it. All right, take care.
Judge, I'm going to be in the middle of, I think my CSC trial is probably going to go most of the.
February 13th.
Thank you, Judge. Appreciate it.
No, you don't. 2025, 9 a.m. Bond continues.
Oh, Judge, just one quick note. She's a top chef. She's been on tether.
She's what?
She's a top chef. She is on a GPS tether. She's only been on it 2 weeks. There's been no violations. It's hindering her work. She lives nowhere near the alleged victim in this matter, and she's asking if the court would please consider. She seems like a very honest woman to me. That she will have.
In what way is it?
Pardon me?
What way is it hindering work?
Because I'm actually kind of the face of my job. All my other employees, everybody works kind of the back. I'm the one that's serving food. So my boss yesterday told me just, hey, it's not really a good look for the company with me walking around with the tether, kind of serving clients of different businesses and different clients we have, dropping off orders that I deal with. I deal with all the ordering and different things.
Response.
Your Honor, we would object to any modification of the bond. Given the facts of this case, the defendant broke into the victim's residence while she was out of town, threw bleach on her clothes and damaged them. Also, stole $350. We feel a tether is extremely appropriate.
Judge, again, I'm not to argue the case here. That's just a bunch of baloney. This lady was invited over there. It was a past relationship, and she went over there. The lady told her where to go into the house. Nothing was taken. Nothing was destroyed. She lives nowhere near this lady. She's a hardworking lady. I don't want to lose her job. Would you please?
Well, I don't want her to lose her job either, but I think you're saying she was invited over. That's not the facts that we have in this case.
There, Judge,
Invitation.
when we hold the exam, there will be texts showing that she was invited over there. She went over there, there was nobody home, she left. All of a sudden now, later, that says this is taken, this.
Well, if you have those messages, I'll consider them, but I don't have them in front of me.
Yes, sir.
I don't have them in front of me at this point. So certainly you can raise that before me, Mr. Killawall, get it to the prosecutor. We'll take a look at it.
Yes, sir.
But at this point, motion for bond reductions are not.
Thanks, Judge.
Somebody could do this.
Judge, I will get, I was just appointed on the case. I talked to her last night. She says.
I heard that.
And she said she sent me the text messages. I will forward to the prosecutor and to your honor. And hopefully you'll change your mind,
Your Honor, may I speak or? you
just
know?
real quick.
Am I able to?
I guess he gave my answer. Go ahead.
Okay, sorry. So just really quick, I was in touch with, another attorney, so he was, of course, just appointed to me. My other attorney, I have sent them all the text message proof. She has tried to contact me through everybody else even around.
Ooh,
My ex-girlfriend, we used to live together, and pretty much we used to live together. We had a breakup where I stopped having contact with her. We were actually raising a child together. So she pretty much lured me by blowing up my phone, literally, I mean, every single day up until I went over there saying to come over.
I may understand all of that.
Yes,
What I'm indicating is that I don't have anything to the contrary of what I have. If you send it off to another attorney, you need to get it from them and get it to Mr. Killawall
yes,
so he can do what he just said he was gonna do.
yes, sir. I was asking because I live nowhere near this area.
I
So I was
heard that
asking-
also.
Yes, am I able to show the messages to him today to be able to show to you today? You know,
I think that if you get them to your attorney will then make the decision as to getting them to the prosecutor and then how to get them to the court.
yes, sir.
we'll do that today.
Anything
Okay,
else?
yes, sir. Yes, sir.
Thanks, Judge. We do appreciate your consideration in this matter.
Yes.
Thank you.
Thank you.
Yes, same. Court call.
Mr. Driscoll would very much like to get this matter resolved as quickly as possible. I spoke to Ms. Zinda about it. At this time, there isn't an offer yet. She has to speak to the victim in this case.
How did your conversation with Ms. Indigo?
Well,
Did
she's
she just
pleasant.
repeat the police report to you?
No,
No, I just thought I'd
she
ask.
didn't have to, Judge.
I just thought I'd ask, because that's what I'm here.
Oh, no, she didn't.
Oh, okay. All right, that's what I thought. I
She was
didn't
very
think she
pleasant.
did that. I just thought I'd ask.
So my client wants to get it resolved as quickly as possible. He's
All right.
asking for a 1-week adjournment if the court granted, but I told him the court would.
Are you gonna be able to get it done in 1 week?
She'll talk to the victim, I'm sure, within a week and let me know if they're.
Oh, that was cordial.
Thank you, Ms.
And
Zinda.
again, it had nothing to do with the police report. The 30th.
Thank you, Judge. Next week. And I do not have a bond argument. Thank you.
What'd you say?
I do not have a bond argument.
You don't? Okay, good.
Now he does.
He does now?
Yes, Judge. My client is asking Your Honor to consider a personal bond in this matter. He says he does not have a violent record and he would like to be able to be released. But we talked about this in holding. I told him if you gave him a 1-week adjournment, you're unlikely to change the bond. But he is asking that you change it anyway.
I'll take it to him. Okay, now here we go. Ms. Linda.
Given the defendant's history, he has a DV from 05 and a dismissed DV, a child abuse fourth, and 2 A and Bs. In this case, they had been dating 2 years and the victim was 3 months pregnant with his child. He was upset that she wasn't getting an abortion, stated, "You're not gonna get rid of that baby," and pulled out a folding knife on her. She went to the bathroom, locked the door, and called 911. She then attempted to leave the store that she was working at, grabbed her by the throat, he then headbutted her. He then began to demand that she give him her phone as she was calling 911 and was pulling her across the floor of the store by her hair before fleeing. Immediately after fleeing, he then called 911 himself to say she was making a false report and that he was in Detroit, when in reality, it was shown that he was in Ipsy. Her dispatch is at House of Liquor. Do you have facts in this case, Your Honor?
Nothing conditional, Your Honor.
I'm surprised his bond is actually so low. but I'll leave it where it is at this point in time. Motion for bond reduction is denied.
Thank you, Judge.
Bond will
For the hearing.
Oh, sorry, Judge.
No, you're not. You just kept going.
That's my fault.
No, it was not your fault. Don't cover for him.
I did not hear you, Judge. I was having a spirited conversation with Ms. Londy.
Is there any other time?
That's what I'm talking about.
Thank you, Judge. This is a case with a substantial amount of restitution. My client is in the process of selling properties. He is asking for one last adjournment. He said if it's not sold by then we can proceed. But he's hoping to be able to pay it all off, Your Honor. He said about 4 weeks.
I know he was trying to sell it the last time.
Yes, they just came the holidays and and that, so it kind of postponed things and bureaucracy with paperwork and that. So I need one last time, please.
Response from the people. Because I remember your last time. Because she kept saying, we're never going to do this again. It's not going to happen. I remember the whole thing. It's like ingrained in my brain. But go ahead. What's the story today?
Great day.
Yes, it is.
Beautiful day. So for the record though, we've been adjourning this case for several months. I want to say since August.
Okay.
And the defendant keeps saying he wants to sell property, sell items to pay restitution. I have no record of any request to actually start putting restitution to the court of any kind. And we've been very clear with this case that there will not be a misdemeanor offer. Oftentimes, I know that there can be arrangements made for someone to continue to pay restitution in the hopes of receiving a misdemeanor. We're talking over $130,000, I believe, in this case. We're not in misdemeanor territory. There will not be a misdemeanor resolution. So I understand the defendant wishes to have another adjournment, but unfortunately, there's been no monies paid to the court for restitution. There will not be a misdemeanor offer. So I'm leaving it in the discretion of the court, of course, but I'm not sure we're accomplishing anything here other than just delaying the proceedings.
Obviously, Your Honor, my client has lost it.
Wow. Yes, it's very succinctly put.
It was. She's an excellent attorney, Judge.
Oh, she is.
Yes.
But because she told you this the last time, but you didn't listen. So go ahead.
Thank you. Obviously, there will not be payments in this kind of case. It'll be a lump sum if he's able to make the sale of the property. He's not working. He lost his job as a result.
Real property he's trying to.
Yes, Judge. So this will be a lump sum type of deal. If for a middle ground, if the court would consider
a middle ground,
yes, Judge, to move the case
a
forward.
compromise.
Yes, Judge. We can set this for exam in 4 weeks, and at that time, it will move one way or the other, if the court is inclined.
Has the paperwork been done regarding the sale of the property? I'm looking at a victim that obviously would need to be restored. And
Yes.
maybe this is the way that it can happen. Although,
Hey, I just want to thank Painted Blonde and thank you, Kathy, for giving memberships, and somebody else had thrown up memberships too, and earlier, and I forgot all about it. I get tired of watching the court stuff, but let's look. Yeah, John Hartley. So John, he used to always comment in my videos like early, like 4 or 5 o'clock in the morning, and it was always neat to see him come in there. So it's neat whenever you start to pick up patterns of your viewers, and you start to miss people when you don't see them. And that's like with Sivo Girl. She went out for a little bit, but it's great to see her back tonight. But the comments from Joel. Hey Joel, if you're serious, let's have a conversation about it. Sometimes we see one side of it. It's good to see the other side. So reach out. I put my number there. Reach out on there. So, and again, thank you again, Jennifer and Kathy and John for the gifted memberships. It's neat to see that grow. All right, we're gonna finish back up with this.
irrespective of any plea, I'm not saying that.
Has the paperwork for
The sale of the real estate, and where are you on that?
Overseas.
Pardon?
Overseas.
this overseas
That's
property?
my other understanding is
Yes.
this is property that's located outside of the United
Yes.
States.
Oh,
And because Fozzie just wanted to see it interrupted again, he just wanted to see the video stopped again. So thank you, Fozzie, for the memberships there. It's a whole bunch of memberships tonight. Thank you guys.
Which
And,
is,
and my family is working on that process, and it just, it took longer than I was expecting.
He did tell me that
Yes.
his family has a similar property that they
Yes.
sold last month
Yes,
that would have netted enough to pay the restitution. So
Yes.
he's optimistic
yes,
that this will be sold in 4 weeks and he'll have enough to pay a lump sum and pay the restitution off in full so that the victim in this case is made whole.
Give him one last shot at it.
Thank you, Judge.
February 20th, 2025. And bond.
And Lori Loves Law snuck in there too. Thank you so much, Lori. Thank you. Got a pile of them today. I'm not logged into YouTube right now, so it's hard for me to be able to see a lot of this stuff. But I really do appreciate it, you guys, and I appreciate all the support you guys have given the channel.
Continue. You know, Ms. Lundy's position isn't going to change.
I know, Judge.
So
But-
you're trying to wear her down. It's not going to happen. I'm just saying.
So, money changes things. Paying off a big lump sum like this.
Not going to happen. Telling you right now. It's been before me for years. Not going to happen.
Well, you know it better than me, Judge.
You give it your best shot.
I will. Judge. Thank you.
Esteban.
Esteban, he did turn himself in on January 13th on the warrant. He was not picked up on this case. Looking to resolve this matter and a matter that's upset or that's set up in circuit court regarding child support.
Say that part again.
That he turned himself in to take care of this warrant that had been issued and another warrant that was issued regarding child support, which he's trying to resolve up in circuit court. He's looking to resolve both these matters.
But is he being held on the child support?
He's not being held on the child support. He also resolved a failure to pay out of the 14B district court that has a court date coming up next month. That also is a
What date?
I will understand 2/15.
And is he being held on that?
Not being held on that case either. If he were to be let out, he would abide by any community corrections order. Actually, we'd be requesting it based on the charge.
At the time of the arraignment, did you have a hold for the child support?
No, sir.
Motion for bond reduction is granted. Granted defendant $25,000 personal recognizance bond. Defendant is to report to community corrections for 2 times per week testing.
Thank you.
Thank you, Your Honor.
Regarding the adjournment, I don't know how long it would take to obtain the video. 2 or 3 weeks I'd be asking for.
Didn't I already give it a day?
February 6th. Oh,
Yeah.
I didn't write it down.
It's
yet.
written right here.
Thank you.
Your client knew, didn't you?
He's smart, right?
No, you knew, didn't you?
Yes, sir.
He wasn't listening. We'll work on him on it.
Yes, sir.
All right.
Too worried about the bond argument.
Thank you.
Thank you.
Thank you, sir.
Well, that was one good deed I've done today. It's over now.
All right, that's where we ended up at whenever we started the video. I watched it through and ended up not backing it up. It's about that time, guys. I got to get out of here. I got work in the morning. Thank you guys so much for coming out. We will see you tomorrow night. I might have a guest tomorrow night. I'm trying to get him to see if he can do it. If he can, I'll have him on the show tomorrow night and we'll have a good old time. Thank you so much for coming out. We'll see you then.